Thank you for joining iMeet. This meeting is now being recorded. All guests have been muted.
Hi, everyone. Good afternoon. My name is Kutsi Anaki, and I'm a program manager with Equal Justice Works. I'd like to thank everyone for joining us on this webinar on the inclusion of individuals with disabilities in the workplace with a focus on ADA compliance and reasonable accommodations. This webinar will last for about 90 minutes, so we have plenty of time built in for Q&A. We are really excited to be joined by our two co-panelists, Sharon Rennert, who is a senior legal advisor in the ADA division of the Equal Employment Opportunity Commission, and Brian East, who is a senior attorney at Disability Rights Texas. We're really thrilled to have them on the line to provide this presentation that will help offer you all some guidance on this very important topic, particularly as it relates to your AmeriCorps and VISTA Fellows. So with that, in the interest of making sure we have enough time for the presentation, I'm going to turn it over first to Sharon. Sharon, can you hear us? We've unmuted you.
Okay, I can hear you. I hope you and everyone else can hear me. And thank you very much for the opportunity to participate in this webinar. And I, too, look forward to the questions. I think that's often the most helpful and interesting part. But let me get started because I know we are going to cover a lot of material in a relatively short period of time on the Americans with Disabilities Act, the ADA. And the main focus is going to be on what I actually think is the central tenet of the employment provisions of the ADA, the reasonable accommodation obligation. But if we can get to the first slide, let me sort of lay some groundwork here before we dive into the concept of reasonable accommodation. Starting with the importance of individualized decision making. At some point, any supervisor, any manager may well be, if not a decision maker on something that has ADA implications, but you may be involved kind of a team effort to make decisions. And the ADA is structured to encourage individualized decision making in recognition of the fact that when it comes to disability discrimination, certainly like other kinds of discrimination, but certainly with disability, a lot of generalizations, uses, assumptions really lead one to discriminate. And one of the ways to counteract that is to require decision makers to really engage in an individualized process. And we're going to see that when we talk about reasonable accommodation. But for almost any decision with ADA implications, the importance of individualized decision making, which means how important it is, whether you're dealing with an applicant or an employee with a disability, to really get and use specific facts, even if it's a disability that you may be familiar with because you've had another employee with the same disability or a family member or even yourself, doesn't mean that you necessarily know all about this person's disability and how it may be affecting the ability to do a job or not affect it, as the case may be. It's also important, like any law, and it's easier talking to a legal organization because you all get this, certain terminology have very specific legal definitions, starting with the word disability. It's not what any of us as non-medical lay people may think of as disabilities. It's what the ADA defines as a disability. It's how the ADA defines what it means to be qualified. And part of the definition of being qualified, as we will discuss in a couple of minutes, is the ability to perform essential functions. We can't just look at any of these terms and assume we know what they mean. They all have specific legal definitions, and we're going to touch on that, not nearly as in depth as we might, but at least to make sure everyone is kind of working off the same page here. So let's go to the next slide, please. And the main term we are going to be focused on this afternoon is reasonable accommodation. I always think I should put it in quotes because that's how the statute refers to it. It is a legal term of art, and as the slide tells you, it is a change in the workplace or the way things are usually done, with the objective of providing an individual with an equal employment opportunity. And that's the important thing to understand, is the role of reasonable accommodation is not to give anybody an advantage over people who don't have disabilities and who don't get reasonable accommodations. But really, it's about leveling the playing field to ensure that an applicant with a disability, if she needs reasonable accommodation, will have an equal opportunity to compete for a job. And if it's an employee who needs a reasonable accommodation to perform one or more job duties, again, an equal opportunity to succeed in performing the specific job. And as the slide says, the general rule in the ADA is that an employer provide a reasonable accommodation to a qualified applicant or employee with a disability if requested and if doing so does not pose an undue hardship. And we're going to break down a little all those component pieces over the next few minutes. But let's start with qualified. And as you can see, it's really a two-part definition here. The first is what we would think of with any job. I mean, put aside the ADA, what does it mean to be qualified? Well, it starts out with the person meets whatever the general job requirements are, and you see a couple of common examples that many jobs will specify a certain level of education or a certain number of years of work experience or particular types of work experience. There can be many other things. Some jobs require that you speak another language. Other jobs may require certain skill set. So obviously it varies job to job, employer to employer. But whatever those general job requirements are, generally, people with disabilities must meet them too. Sometimes there's going to be some exceptions, but for the most part, they must meet general job requirements. But the second part of what it means to be qualified under the ADA is unique to the ADA, and it is the ability to perform the essential functions of the position with or without reasonable accommodation. And this is where we really first see the importance of the concept of reasonable accommodation built in to the definition of determining if somebody's qualified is a recognition that sometimes a person with a disability, not always, but sometimes, in order to be qualified, the person will need the employer to provide a reasonable accommodation. We don't look at qualified and say, oh, you've got to meet it without any kind of accommodation. Quite the opposite. Again, that idea of leveling the playing field, a recognition that without reasonable accommodation, in some circumstances, you would be putting a person with a disability at a disadvantage, somebody who truly is qualified to do a job. We'll pick up on essential functions a bit more in our next slide. Let me touch, and this is very brief, we could do all 90 minutes on the topic of what is a disability. under the ADA, but I just want to sort of condense it into a few important points. The first is that there's actually three different definitions of disability under the ADA, but for our purposes today, I'm highlighting the two most important ones, the ones that can lead to having to provide reasonable accommodation. The first definition that you see is a person who will have a physical or mental impairment that substantially limits a major life activity. Again, if you go to the statute or the regulations, all of these terms have very specific definitions. What's very broad is impairment, as I like to point out. The common cold is an impairment. But being an impairment is not enough. It's the second part of this definition that's very important here, substantial limitation in performance of a major life activity. A record of such impairment is referring to the circumstance where today a person no longer has, if you will, any kind of active disability. In effect, a person has been cured, but they do have a record, a history in the past. This gets a person ADA protection to avoid the situation where an employer, never mind that, no, I don't have a disability anymore, but I did in the past, the employer still doesn't want to hire me, say, because of this. This can come about, for example, cancer. Had cancer 20 years ago, gone. It's, any doctor, any oncologist would say, nope, cured, not coming back, finished and done with. But an employer is nervous about it. Hey, I don't want, what happens if this person is hired and the cancer does come back, no matter what the doctors say? What does that do to my health insurance? How reliable would this person be? Well, I would get protection under the ADA. It would be illegal for the employer not to hire me just simply because I have a record of a disability. These two definitions might trigger an obligation to provide reasonable accommodation. What's most important, what I really want you to get an understanding of here, is how very broad these definitions are. And the one you will come across most frequently when dealing with reasonable accommodation is that first one, a person who currently has a physical or mental impairment that is substantially limiting a major life activity. This is not what you or I as individuals, as lay people might consider a disability. It's not what a medical professional might consider a disability. It's how the ADA defines it. And it really is meant to be very inclusive, as you see, physical or mental impairments. It doesn't have to be permanent. It doesn't have to even be long-term. It isn't something that's going to last a few days or even a few weeks. I mean, I started by saying an impairment could include the common cold. The common cold will not meet the ADA definition of disability. Far too brief in its duration. That's not going to make it. But something that may last several months, yeah, that potentially can be a disability. So you don't want to think in terms of lifelong or it's got to last years. It's also very broad in the sense it doesn't have to be something that impacts people 24/7 on a daily basis. It may cover what we call episodic conditions. Think about something like epilepsy, where people don't have seizures all the time. Maybe they only have one a year. That's enough to make it an ADA disability. Many mental illnesses, the symptoms are not present all the time. Sometimes it kind of cycles in, cycles out. Again, that will qualify as a disability. Sometimes people can control the symptoms, the explosion in medications that are available that weren't even 10, 15, 20 years ago. So people may have no active symptoms and haven't had active symptoms in a very, very long time, years potentially, but nonetheless, under the definition of the ADA, still would be a disability. So really getting across the idea, very broad definition, and you don't want to rely on your own sense of what you think a disability is. Now, we go back to that concept of essential functions, part of what it means to be qualified, the ability to perform those job duties. Not all job duties are essential functions. Most jobs, in fact, in the 25 years I've been doing this, I've never seen a job that doesn't have both essential and non-essential functions. But essential functions are really the critical, fundamental job duties. And obviously that can differ. Sometimes the position title will tell us what may be an essential job function. Bus driver immediately tells me what an essential function is of that particular position. Here at the EEOC, investigators, that immediately tells me what an essential job function is. As the slide is telling us, one of the things, if you need to figure out in a particular position, is something an essential function or not, is to remember to focus on the objective and not necessarily on the customary way a particular job duty is performed. And I try to illustrate this with a couple of examples here. It's possible, as the slide says, analyzing case law may be an essential function of a position, but not necessarily the ability to see or to read. Somebody who is blind can analyze case law. I mean, just being blind is not going to impact your ability to analyze case law, but of course it will impact your ability to read. You can't see necessarily what's on the written page, or not in the way people who are not blind can see what's on the written page. So here's where the concept of reasonable accommodation may enter. How is it you will analyze case law? And it may be through alternative means. Same thing if somebody, say, with a learning disability has great difficulty reading, doesn't mean that they can't analyze case law, but it may have to be done in a way that's different from everybody else. Same thing, second example about representing a client before an administrative or judicial body. That may be your essential function. We're focused on the objective there. But you wouldn't want to list in a position description or a vacancy announcement, essential function is the ability to speak. Because again, somebody who is deaf may well be qualified to represent somebody in an administrative or judicial capacity, but they can't speak potentially because they are also deaf. So again, that's where reasonable accommodation, in this instance a sign language interpreter who would speak on behalf of the individual, would come into play. So focus on the objective here. All right, now that we've kind of got these key terms at least introduced, let's zero in on the concept of reasonable accommodation. Starting with remembering there are three different areas in employment where reasonable accommodation may be required. The application process may be the first time people need it in order to give them that equal opportunity to compete for a job. The one that will come up most often is the second one, accommodations needed to enable an employee to perform her job or to gain access to the workplace, things like, as indicated, bathrooms, or if there's a cafeteria, those kinds of things. The third area, what the law refers to, is equal access to the benefits and privileges of employment. We have three examples. These are by no means the sum total of all the things that will be considered benefits and privileges, but they give you a sense. And as you can see, some of them do not relate at all to directly performing your job, like employer-sponsored parties. What does that have to do with doing the job? It isn't about that. It's just simply those activities that are defined as benefits and privileges. And it's irrelevant whether it's a social activity. It's irrelevant, as you can see, with the training or staff meetings. whether it's mandatory or voluntary, the fact that, hey, people don't have to go to this training. As long as you're providing an opportunity to other employees, if somebody with a disability wants to attend and they're going to require reasonable accommodation to do so, you can't say, well, it's only voluntary, we're not going to accommodate that. That would be a violation of the ADA. Okay, let's go to the next slide, and you can tell this is important because I put half a dozen exclamation points. The concept of an interactive process that is started with when I talked at the very beginning about individualized decision making. Another concept to keep in mind anytime you're dealing with the ADA is that it's all about process, the importance of a process of decision making. And in this we deal with reasonable accommodation, the interaction between the individual with a disability, applicant or employee, and the employer, whoever the representative is of the employer in this process. Now, usually this is going to start with a request from an individual for reasonable accommodation. That's how an employer generally will be on notice that reasonable accommodation's an issue, got to start engaging in an interactive process. As the slide indicates, there are no magic words required to trigger this process or to indicate that there's a request. And what we mean here is you aren't listening for the words reasonable accommodation or ADA, Americans with Disabilities Act, or the word disability. Rather, as the next bullet indicates, in plain English, has the individual told the employer that she needs something from the employer because of a medical condition? That constitutes a request for reasonable accommodation. It's one of the things when I'm doing training and I'm saying, what is it every supervisor, manager needs to know? This is one of them. Because if you miss this, if you have an employee who comes in one day and says, I have this medical condition and I need you to do X for me, that's a request for accommodation, and if you miss that, you sort of drop the ball right there and you never respond to it, and the next thing you know is you're hearing from the EEOC a charge against you for failing to provide accommodation, and you're kind of like, whoa, nobody ever requested reasonable accommodation, yet here it is. So this is very important for all supervisors and managers to recognize. Be aware it does not have to come in writing. A mere oral request will do. You can ask somebody to put it in writing just to memorialize it. It's not meant to be onerous, but you can certainly do that. Note that the request may come from a third party. One of the most common ways that employers get requests for accommodation, doctor's notes. Almost by definition here, anytime you get a doctor's note that is asking you as an employer to do something for the employee, to excuse the employee from something, think about medical restrictions, that's a request for accommodation. It can come from a third party, a family member. As I said, doctor's notes, very, very common. Another way we frequently see employers missing that a request has come in. Now,
Sharon,
go ahead.
Can you hear me?
Go ahead, Brian.
Yeah, I was just going to add, agree with all your points, obviously. I was just going to add that although it is normal, this interactive process is normally started by a request, informal though it may be, from the applicant or the employee, there are some exceptions to that, and one of them is where the employer either knows or it's obvious to them of the need for the accommodation. So, for example, if the person doesn't specifically request a sign language interpreter, but it becomes obvious that that's what they need, or because they're interacting with someone, or someone uses a service animal to help them with mobility because of blindness, and so they're going to allow that dog on the premises, even though maybe there's no pets policy. So there are exceptions to this beginning by a request, and that is where it's obvious. There are some other ones. If the disability interferes with the ability to make a request, that might be an exception. The employer may have obligations at that point. If the employer prevents the request for an accommodation, won't listen to it if a request is futile. There are strict policies the employer has, and they've already told the person, don't try to go around this. So in those circumstances, in my view, the interactive process has fallen on the employer, and they ought to be engaging in it at that point, even though they didn't get a specific request for an accommodation from the employee.
Thanks, Brian, and yes, agree with that. I think important to point out the EEOC has noted, for example, when Brian says, the disability may prevent somebody from asking for an accommodation. The example the EEOC gives is, for example, what we call intellectual disabilities, what a lot of people used to call mental retardation, where the very nature of the disability probably prevents most people with that condition from understanding even the kind of layperson, very low standard of saying, hey, I need something because of my medical condition. That would be the type of exception here. And I want to underscore one other thing that Brian brought up, and that is the employer's ability, which I would concur with, where you haven't technically gotten any request for accommodation, but you see somebody who is struggling. And here, as a layperson, you don't have to be an expert in a disability, but I see something like, a deaf person who isn't using any kind of accommodation, and there seems to be difficulties in communication. Or I know somebody has glaucoma. They've told me they have glaucoma, and I'm seeing a lot of mistakes in written submissions and their written work that, again, as a layperson, I know the person has glaucoma. This could well be that these mistakes are coming because of a visual problem. An employer under those circumstances is legally entitled to ask the person, hey, I see these errors in your written work. You have glaucoma. Do you need an accommodation? You can open the door right there, and the law endorses that, so you don't have to feel you're going against the ADA in that circumstance by bringing it up. So, all right, let's go back, though. One way or another, that, yes, accommodation is needed or is being requested. What happens? And here's where the true interaction begins between the individual and the employer, and potentially some other people who may be called upon to provide information. For example, if what somebody's asking for is equipment to help use a computer, and you're going, well, what do I know? I'm not an IT expert. But wait a minute, we have an IT person or an IT department. You may be bringing them in. So you've expanded who's interacting here. And it is interactive. I kind of use the analogy of a tennis game, and you're hitting the ball back and forth over the net, that you don't want to just kind of hit the ball over and walk away, or the ball's hit, on your side of the court, on your side, and you walk away with the ball. You want to keep it going back and forth. And the goal here is the exchange of relevant information. From an employer's perspective, two general issues, and really almost one and a half. The first issue, is it a disability? Remember, all they have to do is mention that they have a medical condition. And at that point, if it's not clear whether or not it's a disability as the ADA defines it, that may be where your interactive process begins. And this can include requesting relevant medical documentation that will show something as an ADA disability. But again, remember, very broad. We have a number of conditions that basically are going to be disabilities in all circumstance. No need to be having any interactive process about them. Other things, may require a bit more information. I usually talk about back impairments because they run the gamut. Everything from something that, we're just coming out of winter, and depending on where you are and you're shoveling snow and you sort of throw your back out, no, unlikely. That's not going to be a disability. A few days of rest and some Advil and some heat, you're going to be fine. All the way up to things that are very severe kinds of damage to the spine and are clearly disabilities, and everything in between. So there you may have a bit more of an interactive process. But most of what you're going to focus on is why the need for an accommodation, why the need for a specific form of accommodation that an individual is asking for. And this is really what, if there's going to be much of an interactive process, this is where it's going to be. The importance of understanding what's the problem, what's necessitating in the individual's mind or my doctor's mind that I need an accommodation, to understand that. And if they're asking for something specific, why that? How does that solve the problem? Very important for both the individual and the employer, keeping an open mind, listening, asking your questions, but then listening carefully to the responses and asking questions, because you really can't make an informed decision if you don't have all the necessary information, and the way you're going to get that information is asking questions. And again, kind of the importance, so we've highlighted it, this is meant to be a cooperative process. It's like mutual problem solving, and there's a role for the individual, there's a role for the employer. Very, very important. Next slide.
Sharon, this is Brian. I was just going to mention that you pointed out that the employer has the opportunity to request medical information or other information to confirm that there's a disability and to figure out what the accommodation is. One thing I see, one problem that I see in this area is an employer who, as part of that process, asks the employee or applicant to sign a blanket release. So often not directed to any provider, not limited in time, not limited in scope or condition. And that, to me, is inappropriate. So it really should be a focused request for something that is relevant to the discussion and not more wide-ranging than it needs to be.
And I'll second that. Absolutely, Brian's right about that. If there's one law that you can't treat it as kind of cookie cutter, it's the ADA, and everything you do here really has to be focused and specific, which means investing a bit of time. I'll be honest with you about that, being thoughtful about it, but it isn't as simple as putting a release under somebody and saying, sign all this. And in fact, under provisions of the ADA we just don't have time to get into, that kind of general release in this circumstance could end up being a violation of the law. You've got to be careful about asking for medical information. The next slide gives us a sense of how broad the category. Oh, go back one. You went a little too quickly. Thank you. Reasonable accommodation. Notice almost unlimited possibilities. I'm going to focus in a moment on what are not forms of reasonable accommodation. But this is not all-inclusive. These are some of the more common examples on this slide. But some of my favorite cases have involved things like curtains, window curtains or window blinds that you're not going to see on this kind of a list that have come up for people who have various visual disabilities and windows with no coverings and very bright light that's hurting their eyes. That it's to give a sense of just how broad the concept of reasonable accommodation is, and not necessarily, a lot of times it's everyday items, but you're just not used to thinking of them in these terms here. Let me just very quickly highlight from this list 3 things that are often overlooked. 1, modifying workplace policies. Almost all workplaces have policies and have them for very good reasons, but sometimes without meaning to, these policies can unwittingly end up discriminating against somebody based on a disability. And when we talk about modifying a workplace policy, we're not saying you're going to get rid of the policy in its entirety, but rather, if you will, making an exception for somebody with a disability. Think about rules where people aren't allowed to eat or drink at their workplace, but somebody who has diabetes may need to do so in order to keep their blood sugar levels under control. So you make an exception for that purpose. Removal or substitution of marginal functions. We talked about essential job duties, essential functions that have to be performed. This is the other kind, the marginal, the far less important, the incidental. These might have to be removed or substituted as a form of accommodation. The second to last bullet, changing methods of supervision. Every employee must be supervised, but sometimes as a reasonable accommodation, we may be called upon to change the method of supervision here. So very broad what this concept encompasses. Now let's go to the next slide. Much easier to talk about what you don't have to do, what reasonable accommodation does not require. And first of all, you don't have to remove an essential function. That's part of what it is to be qualified for a job, the ability to perform an essential function. Now, reasonable accommodation may be needed to help an employee to perform an essential function. That would be the role of reasonable accommodation, but not removing an essential function. You never have to lower production standards. That's how the ADA refers to it, but think of it as performance standards. That's really what the ADA is getting at. And it doesn't matter whether it's quantitative or qualitative standard. You don't lower them as a form of reasonable accommodation, but again, reasonable accommodation to enable an employee to meet the performance standard. You don't have to excuse misconduct or performance deficiencies. You don't have to provide what the law views as personal use items, and you see a couple of examples here. A wheelchair would be another example. These are things that are needed on and off the job. They're not about a particular workplace barrier. So these are not things, except in the most extraordinary circumstances that ever an employer would be providing. And you don't have to change an employee supervisor. On the previous page, we listed reassignment. That's where you're actually going to move the employee into a different job. That is a potential accommodation, but not changing the supervisor. An employer can do any of those things that are not required if the employer wishes. I just warn employers, think it through and be careful if you decide to. Okay, let's finish up because I want to get Brian in here more. This may be obvious, but I still always bring it up because we see too many cases where employers seem to forget this. The goal isn't just to provide any old accommodation, but an effective one. You don't get brownie points just for giving somebody an accommodation if it really is not effective. And what do we mean by effective? Well, having identified what the problem is, remember that interactive process, you will now find an accommodation that will eliminate the problem, eliminate that workplace barrier. Sometimes there's only one possible accommodation, but in many instances there may be 2 or even more possible accommodations. Part of this interactive process is an employer may counter and say, okay, you've asked for X, but I've heard what the problem is. What about Y? Would Y solve the problem? You want to feel free to propose other accommodations, but listen to the responses. Because sometimes what in theory sounds like it might be effective, an individual may be pointing out reasons it won't be. Now, individuals can't simply demand the accommodation they're asking for. If there's more than one effective accommodation, the choice belongs to the employer. EEOC is encouraged, where possible, for employers to provide the requested accommodation, but the ultimate choice, as long as it's effective, will be the employer's. But again, remember, important to understand the exact nature of the problem if you're going to identify possible accommodations. And of course, we're going to get into it in just a second, undue hardship, where you can say, oh, I understand this is effective for you, the individual, but it's not effective for me, the employer. And we'll talk about that, but before we do, we're almost done here. Next slide, a trial period. This is nothing that's mentioned in the ADA, and yet we have found it to be one of the most helpful tools in the interactive process, where you can't quite say something will or won't be effective, but you have some doubts as an employer, or the individual has some doubts. And in this kind of situation, a testing period, a trial period, can be enormously helpful. The things that you see on this slide, usually from 1 to 6 weeks, sort of depends on what the type of accommodation is, but the idea is you're not doing it for 6 months. And the goal is to see whether or not it really is effective. Usually this is about performing the job. Notice you don't do it for everything. We're not going to do it when somebody who's deaf says, I need a sign language interpreter. Employer's response shouldn't be, well, let's do it for a trial period. Two of the most common types of accommodations where this is done, telework and modifying work schedules. These are often types of accommodations that employers have concerns about, sometimes very legitimate ones. So this is where you're going to potentially find the utility in a trial period here. Okay, last slide, undue hardship. You've gone through all the steps we've just talked about. It works for the employee, the accommodation, but does it work for the employer, or does it cause some significant problem for the employer? Let me underscore the word significant. The law recognizes that reasonable accommodations may cause a certain level of difficulty or expense. That does not make it an undue hardship. It's the word significant. Now, of course, what does significant mean? And that is not precisely defined, but do note it is a reasonably high standard. You can't come in and just be claiming, oh, this is going to cost several $100s. That has to be a significant expense. Even for some relatively small employers, probably very doubtful that it would meet the undue hardship level. If you're familiar with religious accommodation under Title VII, which uses that same term, you don't have to provide a religious accommodation that's an undue hardship. Please note, it's a far lesser standard under Title VII than what we have under the ADA. So same term, but the ADA has a much higher standard to define this. We look at the overall impact, be it expense or difficulty, on the operations. You don't sort of go to a subunit, so a division or department within the employer. We want to look at the overall. That's the reason that financial becomes harder, because you're not just looking at the budget of a particular department, but you're looking at the budget of the overall entity. Again, this becomes very fact-specific. It's not enough just to offer your own kind of conclusion, but what underlays that conclusion. Okay, that's enough for me. Let me turn it now over to Brian.
Thanks, Sharon. And just if we can back up to that slide one more time on undue hardship, I was just going to note that occasionally something does appear to be an undue hardship, but there may be other opportunities to lessen the cost to the employer. For example, the state's vocational rehabilitation program may be willing to purchase the item, the piece of technology, the piece of software, and therefore the employer won't have to pay for it or won't have to pay for all of it. There are also tax benefits when providing a reasonable accommodation, and that can offset the cost somewhat. So just be thinking about whether there are other options if the expense is so high. Okay, next slide. I'm going to talk about some specific accommodations, and we can go to the next slide. And I'm going to sort of summarize what I think are the main points so far. The first one is assumed coverage, meaning assumed disability. Don't get hung up on that definition. And folks may be aware that under the ADA for the first 18 years of it, the definition of disability became more and more strictly construed. But the ADA was amended in 2008, effective 2009, so effective now, that greatly broadened that disability definition. So even if, the HR professional is aware that there's this case where someone had cancer and the court found not a disability, if that's a pre-ADAAA case, a pre-Amendments Act case, that's not good law. So, again, it's good to sort of have your staff assuming coverage unless it is something like the common cold. Second, focus on what are the essential functions of the job and what accommodations are possible, and engage in that interactive process with the exclamation points that Sharon has included because it is so important. I was going to mention that in addition to the examples on her slide, and as she points out, this is an area for creativity and no list can be complete. No list of possible accommodations can be complete. But there are a couple of resources I would mention. One is the EEOC's guidance called Reasonable Accommodations for Attorneys with Disabilities. It's a pretty extensive document, has a lot of helpful information, but Part G of that lists some types of accommodations, many of which are the same as on Sharon's slide. They also give examples throughout the document that sort of suggest some other possible accommodations. So that's one resource. Another one is something published by the Job Accommodation Network, or JAN. So if you're not familiar with that, and if you just Google JAN, it'll be the first thing that pops up. And it's a great resource for trying to identify accommodations or where to purchase technology once you've figured out what the accommodation should be, and just lots of resources there, understanding a particular condition. And they have a document called Job Accommodations for Lawyers with Disabilities that is sort of a bullet point outline. It is not as extensive as the EEOC guidance, but what it does is it sort of groups by limitation. So for all conditions in which concentration is impacted, it gives some of the most common accommodations that could be used. For all conditions in which memory is affected, et cetera, et cetera. So those are just some resources, but as Sharon indicated, this interactive process allows you to talk to the individual, and they often have some good ideas themselves based on past history, what they're aware of, other people have gotten. But sometimes I've had clients come to me and they don't know what the accommodations are either. So we can all learn by documents like this. Okay, yes, thank you. Next slide. Accommodations and hiring. So that was the first kind of class of accommodations. I'm not going to say too much about that here, but I did want to point out that the employer is pretty significantly restricted in the kind of questions they can ask before making a job offer. And so there are, you just have to sort of, I've given you the link to the EEOC guidance on this. It has a lot of practical examples. Can I ask this? Can I ask that? Yes, no. But you do need to be careful at that initial stage when there is no obvious disability. There's a little bit more flexibility when the disability is either known or obvious to the employer. And there you can ask a couple of questions. Do you need a reasonable accommodation, and what accommodation do you think you need? But again, you don't normally get to ask that of an applicant. That's only if someone comes in and you can see that they're blind or that they are deaf or they're in a wheelchair or something that's otherwise obvious, missing limb, for example. Okay, next slide. One of the accommodations that is very common, can be very important, and which has generated a lot of litigation, is a period of leave as an accommodation. So most of this we know the answer to. Reasonable period of medical leave can be a reasonable accommodation, so that is not contentious. And it also can be an accommodation even if the person, employers may be aware that FMLA entitles the employee to certain leave benefits, protected leave benefits. But what if the individual isn't covered by FMLA because they're a new hire, let's say, or they've gotten the 12 weeks of FMLA and they need a 13th and a 14th week. So a reasonable accommodation of leave under the ADA can exceed FMLA rights. So even if the FMLA doesn't apply, even if the 12 weeks are gone, there may be additional leave available. And where I often see a problem is when the individual says, I need 14 weeks of leave, and the employer says, well, okay, we'll give you 12 because that's what FMLA requires. Let's say it applies here. But if you don't come back the day after those 12 weeks are up, you'll be fired. And that's inappropriate because that initial request for 14 weeks, not 12, is a request for an accommodation. And it strikes me as the rare case in which an additional 2 weeks would be an undue hardship when the first 12 are required by law. So the next, something similar to that is many employers have maximum leave policies, sometimes called no-fault leave policies, or other inflexible leave policies, where on the face of them they say something like, you have, 30 days of leave for the year. That can be sick leave, that can be vacation leave, that can be personal leave. It doesn't matter, but it does not go over 30. And that, again, may have to be flexed as a reasonable accommodation. So the employer can have policies like that, but they should make clear that those can be flexed as a reasonable accommodation. And then finally, sort of following on Sharon's last slide, you don't have to provide leave if it would create an undue hardship. So often, a frequent example of that is someone who has open-ended leave, they don't know if or when they'll ever come back. That is often seen as problematic and not something the employer is required to give. But it's the same standard in assessing whatever leave is requested. Would this cause an undue hardship? And that's going to be specific to the job and to the employer, et cetera. And the final bullet point on this slide is the fairly recent guidance the EEOC has issued on leave as an accommodation, which again is a pretty practical document giving examples of how that interaction around leave is supposed to go. Let me pause for just a minute and ask Sharon if you have anything you wanted to add to that part on leave or anything I've said so far.
Thanks. Just very quickly, I think that what Brian is saying in the leave context about avoiding being inflexible, or put in the affirmative, the importance of flexibility, applies in a number of other areas too when we're talking reasonable accommodation. Think broader than leave policies, just any workplace policies. Being rigid, being inflexible, really can harm you in this reasonable accommodation process. And it will never be a defense to simply say, well, our policy is only to provide FMLA leave, or our policy is that you can't eat at your workstation. in the context of ADA, sometimes you've got to go beyond those policies. And so as Brian's underscoring, I just want to kind of, extend that universe a bit. Also, the EEOC documents that Brian is mentioning, including the one on attorneys with disabilities, everyone participating today is going to get the current list of all of EEOC's disability-related documents and the links to each and every one of them. So some of them you have the links here, but the attorneys with disabilities will be on that comprehensive list. So you'll be getting that. Okay.
Great. Thanks, Sharon. And yeah, that list is terrific and really helpful. Courts generally follow those guidance documents. When I'm assessing a case, someone comes to me and complains about the employer not accommodating, I typically am assessing it in comparison with what the EEOC has said is the way it should go. So those are really helpful, and some of them are regarding specific disabilities, some of them are regarding specific accommodations, some of them are broader, more general, but they are helpful. So the slide up now is about schedule accommodation. So the statute doesn't define reasonable accommodation explicitly, but it gives a non-exhaustive list of some examples. And one of the examples on that list is part-time or modified work schedules. And so courts and the guidance documents from EEOC and et cetera have sort of indicated that some of the things that can mean. A reasonable period of part-time status, using or adjusting vacation leave, taking intermittent leave, an alternate work schedule, a graduated work schedule, so coming back to work and sort of easing into it 2 hours a week, 2 hours a day the first week, 4 hours the second week, that kind of thing. Flexible or open work schedules. Again, this one and all of these won't necessarily work for every kind of job, but they work for many jobs. And with regard to flexible or open work schedule, and that means, for example, the typical workday is 8 to 5, but the person either wants to come in earlier or later and work at the end of the day in such a way to catch up on that, or work 8 hours a day, but there's no specific start time, or it's start time within a range. And so a lot of employers now have somewhat flexible work schedules anyway, and that's particularly true with the federal government. So there are some cases in which the flexible schedule was requested, the employing agency was resistant, and the court was not pleased with the employer's position because they already had this flexible policy. Sometimes the person needs less flexibility. Instead of having shifts that can change all the time, they need a particular assigned shift. So anyway, these are all various things to consider depending on the circumstances and depending on the individual's request. While this is up here, let me go a little bit off topic. And if you'll remember when Sharon was speaking, she was saying that there may be more than one accommodation that will be effective, and it is generally the employer's choice as to which one to implement, and I agree with that. I do think, though, that there are some limits to the employer's choice where one accommodation is much is a substantially lesser accommodation than another. So, for example, what if someone says, I have this condition, and because of fatigue and the need to be near the toilet and the medication I'm on, that kind of thing, I would like to work for the next 4 weeks from home. And so I'll be getting a paycheck, I'll be doing the work, but it'll be a more flexible schedule. I'll be right there by the bathroom, et cetera, et cetera. And the employer says, well, I don't like that one, but I saw on a slide that Brian East did and this presentation once that leave is an accommodation. So here's what I'm going to do. I'm going to put you on unpaid leave. So you're not going to be getting a paycheck for those 4 weeks, but you don't have to work either. So that is, costing the person some money. And that, if the person doesn't want that, in my view, is inappropriate. Also, if you're considering moving the person to another job, it doesn't have to be a promotion, but let's say there's a job that pays exactly the same and a job that pays $5,000 a year less, and the person is qualified for both and they're both vacant. The employer isn't free to just choose the one that will save it the most money. They're supposed to be trying to keep the person, as much as possible with the benefits that they would have had. So again, although it is normally the employer's choice, when there's a selection of effective communications, you don't want to do ones that segregate, cost money, et cetera, when there are ones that wouldn't. Let me just pause there again and see if, Sharon, you had anything to add.
Nope, I agree.
Okay. The next slide is about teleworking, telecommuting, that kind of thing. So this is, as you probably know, more and more common in the workplace to have these kind of teleworking arrangements. And again, there are certain jobs where this makes sense and certain jobs where it may not. But the technology is certainly present now to do it. And there are benefits to the employer as well as the employee. So this is something that employees, in my experience, are requesting more and more, either complete teleworking or partial, where they work 2 or 3 days a week from home or from some other location, and come in on the, because Mondays we have staff meeting, and there's this thing that happens there where I have to be present, so I'll come in for that type of deal. But again, whether it is appropriate or not really depends on the circumstances and the nature of the job. So we see cases where the job requires the handling of secret or confidential information, and there's no good mechanism, nor does the employer allow it for anybody else to take that kind of material outside of the workplace. So that might be a situation where trying to telework doesn't work so well, or if the person is the receptionist who handles meeting and greeting the public, I could imagine through technology that becoming fairly routine, but probably now that may be seen as a difficult thing to do remotely. So the point that I'm making here is when the ADA first passed, we saw some court cases that said these are really a stretch, like they might work, but boy, this is far out there. This is the future. And, the future's here, so we need to seriously consider these if it's something the employee wants, not forcing it on them, but if it's something they want. Again, EEOC guidance on teleworking, which is cited here. Next slide. So the last sort of specific accommodation that I was going to talk about is reassignment, and that is, as Sharon mentioned, the accommodation of last resort. And what that means is that what we want to do is accommodate the person in their current position if possible. We don't want to try to force them into another position. The goal is to allow them to do their job. But sometimes that cannot be done. So when you have the job of a bus driver and the person becomes blinded by a condition, so they can no longer do their job as bus drivers. So now the last one to think about is reassignment. Is there a position that is vacant or is soon to be vacant that is not necessarily a promotion, because that's not required, but that the person is qualified for, and we may be able to move them into that position. So that's often something the employer knows way better than the employee. So the employer should be, when it is a situation, and I do have clients who come to me and say, I admit I cannot do my old job, nor is there any accommodation that would allow me to do it. What I need is a different job there. And so, again, the employer has access to that knowledge of what jobs are open, what jobs are soon to be open that the person might be qualified for. So that's what reassignment is. It is an important accommodation. Again, the old law used to have strict limits on it, but now it's pretty clearly established as a reasonable accommodation and something to be considered at least as the last resort. So next slide. These are just some general comments I was going to make. The first is that when you're doing the interactive process, it's important to do it pretty expeditiously because sometimes the delay is the equivalent of a denial, or delay can exacerbate a condition. So moving quickly is important, or as quickly as is reasonable can be important. Educating management and other staff on the responsibilities. This is obviously important for all the reasons that Sharon has already talked about. And we sometimes see that, let's say, the head of HR, there's a big, the case ends up in court. And the head of HR, it turns out, knew a whole lot about this stuff and could explain all this really well. But the person that was actually interacting with the individual was really untrained and unsophisticated on what the law required, and got the employer in trouble because of that. So making sure that the staff that are going to be dealing with employees with disabilities either know what to do or know who to refer the individual to. I've seen there are some documents on the EEOC's website that probably are not on Sharon's list that are on the order of best practices documents. And they sort of go through things that have happened in federal agencies or in private sector employment where they sort of are pointing out something that can be useful. And one of them I recall was requiring a fairly high-level sign-off when the employer is going to deny accommodations. So making sure that the person with the most knowledge and who has the last chance to protect the employer agrees with the position. So there's lots of things that can be done there. And the final point on this slide is it is against the law to retaliate against people for protected activity under the ADA as it is under Title VII, et cetera. And protected activity includes a request for accommodation. So, just make sure that things aren't done that could be construed as retaliation or interference or some other action taken against the individual because they requested an accommodation. I'm going to stop there, and I think, so here's contact information for both Sharon and for me, and I think we wanted to open it up to questions. There is one other slide here which has some additional resource sites for you, and like I said, even better than this is the total list of EEOC guidance documents related to these things.
Great. Well, thank you so very much, Sharon and Brian. That was incredibly comprehensive, and I can just speak for myself in saying that I learned a lot just from this brief presentation. So we are going to open up the lines for questions. So there's two ways that you can ask questions. You can either type them into the chat box if you're online, and Renee here will read them out to Brian and Sharon so that we can get some response. Or else, if you're dialing in on your phone, we will unmute the telephone line so that you can ask questions. However, we ask that if you are not speaking, if you can please make sure you are individually muted by hitting mute on your phone, so that way we don't get a whole lot of background noise. So we're going to open up the lines right now.
All guests have been muted. All guests have been unmuted.
Okay, great. So the lines are open. Feel free to ask your questions either over the phone or by typing them into the chat box. we're just going to give everyone a second if they have questions or if they want to type something into the chat box. And in the meantime, Sharon and Brian, I actually had a question for you. It's a somewhat sort of abstract question, but I'm just curious to get your thoughts on this. You went through sort of this process that, is required and recommendations about the interactive process that have been provided by the EEOC and so forth. And I'm just wondering what thoughts you have. I mean, this is a very sort of structured, process that's sort of bound up in legal obligations that employers have to their employees and so on. But, do you have any recommendations about sort of how to make this process really sort of human? Because at the end of the day, these are you're working with people and human beings that have different needs, and sort of any recommendations about how to make this process sort of smooth and the least kind of legalistic as possible? I know it's sort of an abstract question, but I'm interested to hear your thoughts.
I think it's a wonderful question because I totally agree with the premise of it. Yes, there's a legal context to it, but in my experience, if this is going to work as well as possible, it really is about keeping it at that human level, which means, again, speaking sort of from the role of the employer as a supervisor or manager, I want someone to be at ease, okay? I want this to be cooperative. So I want to perhaps start by saying, this is about a problem and we want to try and solve this problem. And maybe not quite in the way that you're bringing it to me, but we want you here. We value you as most of these will be about employees. We value you as an employee. What can we do to make this work? So let's start. And you can kind of lay out, I may be asking questions, but it's so that I fully understand what's going on. So you kind of explain what you're doing here. Because sometimes, it's about putting yourself in the employee's shoes. If you start asking questions and they're starting to think, this means you don't think I need something, or you're going to deny me. So again, trying to reassure people, put them at their ease. Here's why I'm asking some questions. A lot of times people are concerned, I think Brian touched on confidentiality, especially given the sensitivities and unfortunately the stigma that still attaches to certain types of disabilities. Think of certain mental illnesses, HIV infection and AIDS can still have stigma attached to it, which means even bringing it up for many people, asking for accommodations is very difficult. And again, from an employer's perspective, a way to keep people calm and cooperative is to address that. I appreciate you asking for accommodation. Please understand as part of this process that the law requires that this information be kept confidential. It just can't be shared with everybody, and you can say the only time it might be shared is somebody who has to join in the decision-making process. So if I know I'm going to have to say bring in my HR person, I don't want to say, it's not going to go beyond me, the supervisor, but I have to bring in the head of HR, but confidentiality will apply there too. Head of HR can't just go around blabbing all this sensitive information. So that's another way to kind of, head-on address some things, but keeping it positive, a kind of can-do attitude. You can also, if the need be realistic with a person and say, until we get to the end, I can't make you a promise I may not be able to keep. But again, that goes so far, I think, to really facilitating a successful interactive process. Brian? Your thoughts?
I agree with all that. I think the attitude is really important, the attitude of the employer. On the other hand, a good attitude doesn't sort of fully take the place of actually understanding the obligation. So it's sort of both things. And I think having worked in legal services and having worked for nonprofits, I think it's easy for those of us who think we're, sort of do-good organizations and that who who have a personal interest in avoiding discrimination to just assume that, well, we won't do that, we won't be discriminatory. But this accommodation obligation sometimes requires things that we may not have encountered before. And so going through the steps that Sharon has laid out, looking at some of the examples and that kind of thing can really help. Just to use a bad example, I one time had an agency tell me that even though the interpreter they used for my client had very limited proficiency, still she had a good attitude. And to me, that was important. But if someone asked me to translate, this conversation into Russian, I'd have a really good attitude about trying it, but it would be really bad. So I think that attitude is important. I think knowing the rules are important. There are disability etiquette papers out there, but in my experience now for over 20 years working with clients with disabilities, I learn things all the time about what terms to use and not use, but my clients and the individuals I've interacted with never hold that against me. They may say, I don't like that term, I like this. But but don't get hung up on that. Have the conversation. The last thing I'd throw out is the employer can be sort of forward-thinking about this. So having policies or trainings or whatever before the need arises that says the ADA might require accommodations. We'll take we want to be serious in meeting the accommodation needs of all of you, because what sometimes happens is someone gets an accommodation and the coworkers are like, why do they get to do that? I don't. And you're not free to say it's because they have disability X and this is a disability-related accommodation. That's private to coworkers. But telling people in advance that this is your attitude, that you're open to these requests, that you'll take them seriously, as Sharon says, not making promises, but sort of promising the right attitude and a knowledge base really helps.
And just to sort of sum it up, you have our contact information, and speaking for me at the EEOC, part of knowing the law is also sometimes knowing that you need to reach out and get some assistance. And in doing this for 25 years, I won't say that I've heard it all, seen it all, but I've heard and seen a lot. And that experience can often help the people who contact me now. And, in terms of coming up with ideas or saying, have you asked this question or that question? And any contact with me is also confidential, by the way. It never goes beyond speaking to me, so I'm here to assist at any point.
Thank you so much to both of you for that really comprehensive answer and your thoughts on that. I think that's probably one of the trickiest aspects of this is keeping it human, but keeping it according to what the law requires. So thanks for that. We have a question that just came in through the chat box.
Okay, our first question is if the slides will be presented to you after the fact. Yes, we'll listen to a recording and a copy of the PDF slides afterwards. And then our other question is from Kate Richardson. Can we talk more specifically about reasonable accommodations for mental health conditions such as depression?
I can start with this. It's a very broad question in terms of what are possible reasonable accommodations for depression, because there's almost unlimited possibilities depending on what the specific problem is and in the specific job and the work environment. For something like depression, which can manifest a lot of different ways, a lot of different symptoms, it's really hard to sort of pinpoint, well, here are the, one or two reasonable accommodations that may come into play. Brian mentioned earlier, and I want to kind of second this, a good resource, which certainly would include a list of possible accommodations, is the Job Accommodation Network. I use them all the time because they have experts, counselors, who are experts in different disabilities, and they have an awful lot on their website. You don't necessarily even need to speak directly with a counselor. You may get a lot of information just off their website. But for various disabilities, they will include possible kinds of accommodations, but also you can talk to a counselor, and if you give specific information, and the more specific it is, what the exact problem is. So, calling the Job Accommodation Network before you've even started getting into the interactive process may not be as helpful as starting the interactive process and then calling the Job Accommodation Network with what you've learned. But they can also help to brainstorm. Basically, that's what they do, is brainstorm. It's a free service. Brainstorm about possible accommodations. Also, every disability, as far as I know, has its own organization. And it varies, but some of them also can be very useful for getting information. So that's, I usually start with the Job Accommodation Network, and if I feel I need to, then calling a specific disability organization. So again, if you have either as part of this call or afterwards you want to contact me if there is sort of a specific situation you're dealing with, then I'm certainly happy as best I can to brainstorm about what might be possible accommodations.
Yeah, I'll just jump in and repeat. So on the Job Accommodation Network website, there's a search box, and you can type in depression, and likely you will find various documents, typically a disability-specific paper on what the disability is, what its typical manifestations are, and what common accommodations are. So that's a good place to start. In my own practice, I would say the most common accommodations that my clients with depression need or request are the leave and schedule accommodations that we've been talking about. A period of leave for therapy, to reduce stress, to change medication, etc. Alternate schedule, or an alternate schedule that will allow them to see the counselor on whatever schedule they've arranged for that. So those are some things. I don't know if that answers the question, but.
Great. Thank you so much. That's extremely helpful. Just going to pause. We don't have any other comments in the chat box, but if anyone has a question to ask over the phone, feel free. The lines are still open. Okay, great. It doesn't seem we have any questions that are coming through over the phone or in the chat box, but I recognize that many of you may have individualized questions that may not necessarily be appropriate to ask in this setting. So that's perfectly fine, and really appreciate that you, Brian and Sharon, have offered your contact information so that folks may be able to reach out to you individually. So unless Sharon or Brian, you have any other last thoughts, we can wrap it up.
This is Brian. I don't think I do. I also would be happy to field contacts. I only represent individuals with disabilities, so those are the easiest for me to interact with. But occasionally, I do have employers that just want some general information about how to proceed, and I'm happy to try to give general information, even if I can't give really detailed information to the employer side. Great. Thanks so much for that. So just wrapping up, as Renee mentioned, we will be circulating a recording of the webinar, the slide deck in PDF form, as well as the comprehensive list that Sharon mentioned of EEOC resources after this webinar. So feel free to share with anyone who wasn't able to attend and would like a copy of those materials.
Just want to thank you both again so very much for this, for your expertise and for this very comprehensive presentation, and just really appreciate that you've offered and volunteered your time with us today.
You're welcome.
No problem.
Great, thank you. All right, everyone, thanks very much for your participation, and we will wrap it up. Thanks, and have a great afternoon.
Thank you.